Hey there. Hey, Bill O'Leary here from Legacy Planning Law Group. On behalf of everyone here at Team Legacy, I hope your week's been going well. And I'm coming to you on this Thursday afternoon to talk about a topic of interest in the world of estate planning. This actually is part of our Thirsty Thursday series, which we're going to start doing every Thursday afternoon at this time. So if you're thirsty for knowledge, then you found the right place. So the topic for today is, can you do your own estate planning yourself? Well, let me start off by saying, of course you can. You can do anything you want. It's a free country. But I think the better question should be not can you do it, but should you? Look, I can tune up my car if I want to. No one's stopping me. But the better question is, should I? Frankly, I wouldn't know where to start, and I'd probably break something. You know, the phrase do it yourself conjures up images of a weekend trip to Home Depot, maybe a bruised thumb, but certainly a feeling of satisfaction that may come from a freshly painted room or a repaired deck. But even the experts at the do-it-yourself publications like This Old House frequently remind us not to take on a project that's normally handled by an expert, maybe a plumber or electrician. You know, the consequences of that, a broken pipe or electrical short, could have disastrous results. In recent years, do-it-yourself or DIY providers have emerged in many fields, ranging from tax preparation to estate planning. And these services purport to provide at a low cost the ability to generate computer-drafted documents that, you know, may bear some of the hallmarks of professionally prepared documents. And now, while these services provide tools to enable the project to be done as a DIY, they should be used with extreme caution, as with any home improvement project. You know, even highly skilled people that are skilled in certain things should think twice about venturing beyond their area of expertise. You know, I'm reminded of a famous federal judge some years ago who said about tax law, he said, quote, "After 50 years of law practice, I would no more have the audacity to formulate my own tax return than I would engage in open heart surgery." Those who seek to replace professional legal advice with a do-it-yourself online document in a complex field like estate planning should understand the effects of their actions. There are a number of online DIY providers, including well-known ones like LegalZoom and Rocket Lawyer. DIY providers promote themselves by charging low rates for documents. But as I'm going to explain, the greatest danger of preparing your estate plan with one of these online platforms is that they lull you into a false sense of security. Let me focus on LegalZoom. They want you to believe that the process of preparing a will is as easy as filling out the blanks on a standardized, online portal. They try to lure you in with a cheap product and a process that takes less than a half an hour to complete. And they try to assure you with testimonials that their product has given them peace of mind. They give you a portal that simply gives you a, quote, general understanding of the law. Interestingly, the portal also has a disclaimer that the will that they give you is, quote, not guaranteed to be correct, complete, or up to date. Now, interestingly, LegalZoom makes a disclaimer that their document preparation services are not a substitute for the advice of an attorney. But then they go on to try to convince you that the advice of an attorney isn't necessary, and that the document you get from them will be just as effective as one that an attorney creates. That is such a disservice. Really, people deserve straight talk instead of talking out of both sides of your mouth. There's a very telling admission. Again, I'm focusing on LegalZoom because it's the most well known. A telling admission on the portal that says, quote, 80% of people who fill in blank forms to create legal documents do so incorrectly. Yet despite this error rate, they try to reassure customers that professionals are there to help, that customers can have peace of mind knowing that LegalZoom professionals will customize their will based on their legal decisions. Well, the problem is LegalZoom is not a law firm. In fact, they candidly admit that, even in their TV commercials. So they are not allowed to review your answers that you put down on the portal for their legal sufficiency. They're not allowed to draw legal conclusions, not allowed to provide legal advice, and they're not allowed to apply the law to the facts of your particular situation. All LegalZoom does is provide general information on legal issues that are commonly encountered. The guidance they give only says that, well, gee, maybe a majority of their customers have answered a certain question in a certain way. Well, the problem is that everyone's situation is unique. Just because the majority of their customers have answered a question in a certain way doesn't necessarily make it right for your individual circumstances. So if the document contains serious legal mistakes, you'll never know. Well, it won't become a problem until after you die. And the people left to deal with the mistakes are the people you're probably creating your will to protect. When you think about it, a will is one of the few human acts that survives death. It carries a legacy that can have a lasting financial and emotional consequence on those who matter most, our loved ones. A person who drafts his own will must bear in mind that the critical test of their efforts will occur after they die. At that point, their voice has been forever silenced. Mistakes made in the drafting of such an important legal document can profoundly alter family relationships, leaving family members at best confused and disappointed, or at worst locked in some sort of hostile litigation. So consider this a horror story with online wills. Somebody we're going to call Anne. She created an online will. The online portal prompted her to list specific assets in the will and to say who would get them. Anne wanted everything to go to her sister. Well, her sister died before her. Incredibly, the online portal did not include something called a residuary clause, one of the most basic things a will should have. A residuary clause is a way to decide who gets everything else you own that's not specifically listed in the will. The online portal simply did not have a box to fill out for the residuary clause. So when Anne died, two of her nieces stepped forward to make a claim against her estate. Her nieces were children of another one of Anne's siblings who also died before Anne did. The nieces filed a lawsuit in the probate court. It was litigated all the way up to the Florida Supreme Court. And even though it seemed clear to everyone that Anne wanted everything to go to her sister, the court ruled in favor of the nieces. Imagine the legal fees spent just because the online will provider screwed up. The online will provider was not held responsible, by the way, because their online portal had the disclaimer saying that the will is, quote, not guaranteed to be correct, complete, or up to date. And as icing on the cake, one of the judges wrote that the case reminded her of the old adage, penny wise and pound foolish. Anne used an online form without legal advice, which led to a terrible and unintended result. So, should you try this at home and do your own will as opposed to getting help from an experienced estate planning lawyer? Well, before you take the leap to draft your own estate plan documents, consider some important issues. Number one, there is the risk of not properly stating your dispositions. A proper will must clearly state what's called the testamentary intent to dispose of assets. The language must be used in a way that is dispositive, that's final, that's clear. A simple letter of instruction or word stating a person's general preference isn't going to cut it. Those who draft their own wills run the risk of using words or terms that could fail to make effective dispositions. The failure to use words of what's called proper testamentary intent could void the will, and so that's a risk that people run in doing their own wills. Consider this: who's going to explain your intentions? So if a dispute arises, the court often is going to hear sort of competing allegations as to what your intentions were, perhaps from interested family members. Well, who's the court going to believe? Figuring out the intentions of a deceased person is among the most difficult tasks that any judge has. Well, many judges will look to the voice of the person who died through the estate planning lawyer who talked with the deceased person and knows what they intended. Can't do that with an online will. Then the issue of births, deaths, marriage, divorce, incapacity, those life events. Each of these events may profoundly alter a person's life, and they may also alter the deceased disposition or the disposition of the estate that the deceased wanted. So for example, what happens to a spouse's share under a will if you get divorced? Does that former spouse get it, or does it go to someone else? Who? And what if they're minor children? Will the court appoint a guardian to hold and administer the assets? And you think it's possible the court could appoint the former spouse as guardian? The same types of considerations apply to all of the changes in family relationships. A proper estate plan should address these contingencies. Now, how about this one? The simple plan. So consider the elderly woman with what seems to be a simple plan. She has 2 loving adult children, one who lives with her. She has 2 assets, a house worth $300,000 and a bank account with about the same amount of money in it. What's her simple solution? She'll keep both children happy by dividing things equally. So she does up her own will, leaves the house to her son and the bank account to the daughter. She tucks the will away in her desk and lives happily ever after. What about the kids? Not so happy. After she dies, they realize mom spent down her bank account to pay her bills. So there's nothing left for her daughter. Remember, the bank account was being left to the daughter. So one can envision the son, who, by the way, again, is getting the house, telling the daughter, "Hey sis, I feel sorry for you, but mom wanted me to get the house." Well, the daughter, of course, doesn't agree and thinks mom would have wanted them to split the house. She sues the brother. So with proper counseling and advice, that suit could have been avoided if mom's intentions were properly expressed. And then lastly, consider this: advice and counsel. As an estate planning lawyer, they provide more than technical expertise drafting documents. We provide advice and counsel. We have an extensive experience in counseling clients in these most intimate decisions. For example, help couples sift through various possible options in selecting a guardian for the minor children. You know, that decision often seems simple, but the ideal guardian, the candidate there may have less than an ideal spouse. They may lack financial experience, or maybe they're unable or unwilling to serve. Spouses may disagree as to the choice of guardian. They may need advice to understand a guardian's role. No matter how hard you try, you cannot find advice and counsel on the internet. You see, in that situation, the estate planning lawyer could provide that advice and counsel, walk them through understanding how best to appoint a guardian. Look, on the internet, there is a lot of information about estate planning. Not all of it accurate, by the way. But the fact remains, the internet cannot give you advice and counsel, which is something you can't put a price tag on. So the bottom line is attorneys do more than just draft legal documents. They advise you on the best way to protect your family and to preserve and distribute your assets according to your wishes. Now, yes, taking the advice of an attorney costs more, but as LegalZoom admits, 80% of people who fill in blank forms to create legal documents do so incorrectly. So are you going to beat the odds? Are you willing to take that risk? So I hope you enjoyed this talk. Again, I plan to do it again next Thursday afternoon at the same time as part of our what we call our Thirsty Thursday series. It'll be same day, same time, different topic. So if you are thirsting for knowledge, we will quench your thirst. So this is Bill O'Leary signing off for now, and on behalf of our entire team here at Legacy Planning Law Group, our Team Legacy, we want to thank you for spending some time with us. And go make it a great day.